This is the second or third in a long series of efforts by the California Civil Rights Department and the Department of Real Estate to talk to property managers about fair housing. We've covered other topics in the past, and we look forward to doing more topics in the future. So if you have ideas of subject matters that you are interested in hearing from the Civil Rights Department or the Department of Real Estate, please drop it in the question and answers or the chat, and we'd be happy to follow through and try and put together a presentation on those topics. But as an introduction from the Department of Civil Rights, we have Kara Broadpure, and then from the Department of Real Estate, we have Chika Sundquist and myself. So as we get to the various portions of the presentation, each of us will introduce ourselves again and sort of give a little background of who we are and what we do at our respective departments. But it's very exciting for us to come together. We work collaboratively, the two departments, quite a bit. The Department of Real Estate focuses on occupational licensing, but we do have quite a big overlap when it comes to issues involving fair housing. And when we do get fair housing complaints, we work closely with our partners at the Civil Rights Department. Civil Rights Department has a big portfolio, and Kara can talk a little bit about that. But today's focus obviously is on fair housing. I should say that we are going to make efforts to make today's presentation available on the websites of both the Civil Rights Department and the Department of Real Estate. So it should pop up there, if not later today, in the next few days. So if you're interested in copies, you will be able to obtain them. And finally, before we launch into the actual presentation itself, if you have questions, I would encourage you to place them into the Q&A section of the Zoom call. And then we will try and answer them as we go, or if there's time permitting, we will address them at the end. With that, we're going to start. I guess we have just some quick, I guess, admonitions and disclaimers. Just want to let everybody know that we are recording today's event. So it will be available for future reference. Number two, this is for informational purposes. We are not trying to create any type of substantive law or new policies or create any type of attorney-client relationship. Although several of us are attorneys, we are doing this to provide you guys with information and guidance about how we move forward and address the subject of fair housing. So with that, Kara, if you could flip to the next slide. So before I get started, I'll introduce myself, and then each of the presenters will introduce themselves as they present. But my name is Steve Lerner. I'm the Assistant Commissioner for Legal Affairs. That's a fancy title for Chief Counsel at the Department of Real Estate. I oversee the department's legal program. So I provide legal advice to the executive team and commissioner, and I oversee the lawyers handling our license discipline cases. I also am directly involved with the department's promulgation of regulations, which there is one regulation I will talk about as part of my presentation. But with that, fair housing is a very interesting topic. It's a very timely topic, but DRE has been involved with housing issues for a long, long time, and fair housing for equally a long time. But DRE's mission is basically to protect California real estate consumers. And we do that through four essential means: licensing, regulation, education, and enforcement. And so with our licensing, just to give you a quick overview, we have about 435,000 licensees. The licensees break down into basically two types of license classifications: real estate brokers and real estate salespersons. About a third are licensed brokers, about 2/3 are licensed salespeople. We do provide other types of licensure, but that's the bulk of our licensed population. In order to enforce, we develop regulations that regulate the licensed population and their practices. We are governed by the California real estate law, which can be found at Business and Professions Code, Section 10,000. We also have responsibility over the Subdivided Lands Act, which is found at Business and Professions Code 11,000. In addition, we promulgate the regulations. We are first and foremost very interested in trying to educate the public. And certainly we want to try and educate long before we jump into and start wearing our enforcement hat. And we do education by conducting presentations like this one. We go out and speak at stakeholder events. We write letters and news alerts that we post on our website and that we circulate in our quarterly bulletin. And then finally, we do have a strong enforcement effort, which is comprised of our enforcement, audit, and legal staffs that take complaints and look into them for violations of the real estate law. And when there are bad actors that have committed violations, we do take enforcement action, disciplinary action against their licenses. So it should be important to note that well, we basically have a large mission, which is to protect California real estate consumers. By statute, that is our very highest priority. So when everything is balanced against everything else, the protection of California real estate consumers always trumps all the other things we do. So we try and keep that in mind when we are involved with anything, licensure, regulation, education, enforcement, or any of the other things that we do as a department. So with that, Kara, if you can flip to the next slide. So today's topic is about fair housing. What is fair housing? I mean, in a nutshell, you see the definition up on the screen, but in a nutshell, it's essentially similarly situated people should have similar experiences. And so basically, when you're in the housing market, everyone should have an equal playing field and have access to touring houses, making offers on houses, buying houses, renting properties, regardless of any of the characteristics that make them a unique human being. So you should not factor in making houses available or offering a one price versus another price or offering tours based on certain characteristics. So what you see there are all the types of protected classes or characteristics that could constitute violations if you favor one over the other in the housing market. But that is a very generic description or definition of fair housing. We'll talk more about it as we move through the slides. But Kara, with the next slide. So basically the world of fair housing is governed by both federal law and state law. And there's a number of laws out there. I just want to focus on some of the primary non-discrimination laws. At the federal level, it's the Federal Americans with Disabilities Act and the Federal Fair Housing Act. And at the state level, we have the Unruh Civil Rights Act, the Fair Employment and Housing Act, and the Holden Act. And so focusing on those three state laws, just very quickly, the Unruh Civil Rights Act focuses on all business establishments, including housing and public accommodations. The Fair Employment and Housing Act, when it was first passed, created what was then the Department of Fair Employment and Housing. That department has since changed its name to the California Civil Rights Department. Kara can talk about that, but that occurred in the last 12 to 24 months. But in addition to creating the department that is now known as the Civil Rights Department, the Fair Employment and Housing Act focuses on both public and private employers and the housing and housing for people. The Holden Act focuses on the financing that is available to fund the purchases or rent of real property. So all three have very strong components that address fair housing, but there are three separate statutory bases that here in the state we can pursue, as well as two at the federal level. So Kara, if you can flip to the next slide. So what you see here is the first of two slides that talk about the protected characteristics. All the ones you see here are covered both by the federal law and the state laws. On the next slide, you'll see 4 additional characteristics that are only covered by the state law. And those 4 are the last 4 that are identified: primary language, immigration status, citizenship, and age. But any one of these is a protected characteristic. And if there's discrimination against any or more than or all of these characteristics, it could create liability for the party causing the discrimination. So for instance, just looking at the screen that's up, the first one is family status. If during the process in which you are offering a house for sale, you start inquiring about family status of the buyer, that could pose liability and put you in violation of fair housing laws, because that's a protected classification. And you're basically discriminating by treating someone that has a familial status different from someone else who has a different familial status. As you can see from the prior slide and this slide, there are quite a few protected characteristics. Some are very apparent. You can look at someone and see whether or not they fall into some. Others are not so apparent, but all of them are protected characteristics. So I suggest that you be mindful and review the list and be familiar with this list. Kara, the next slide, please. So the rights that flow from protected characteristics. So basically, regardless of the characteristics that you have, and we all have them, you have the right to housing free from harassment. You have the right to operate licensed childcare in a provider's home. You have specific protections for people, and I should say there are specific protections for people that have criminal histories who are looking for housing. That's been an area that those folks have had a great difficulty in finding housing simply because of their criminal history. So the legislature has taken extra steps to identify and take additional steps to protect those individuals. But essentially, it goes back to the statement I made earlier. Similarly situated people should have similar experiences. So everyone like me who's interested in buying a house should be able to have the opportunity to look at that house and make an offer on that house, regardless of their unique characteristics. So with the next slide. So we do have at the Department of Real Estate regulations that address fair housing. And the regulation itself was updated about 2 years ago to reflect changes in the laws. A number of protected bases have been added to the federal and state laws over the almost 2 years, or 20 years, I should say, since the last time regulation 2780 was amended. But 2780 is rather extensive. It actually, if I had several slides, it would cover several slides of material. But in a nutshell, what it basically covers are these characteristics that, for instance, you cannot refuse to rent a property to someone who has a protected class, or you cannot steer a person away from a property or steer them towards a property because of a protected class. You cannot misrepresent the availability of the property because of a protected class. So the regulation itself is rather extensive, but there are a lot of do's and don'ts within the real estate industry. You should be familiar with them because violating any of the regulations could pose liability and run the risk of license discipline against your license. With that, the next slide, Kara. So now I'd like to turn it over to my colleague, Chika Sundquist. Chika, do you want to take it from this point?
I'd love to. Thank you very much, Steve. I am Chika Sundquist. I'm the Assistant Commissioner of Enforcement for the Department of Real Estate. And I just want to cover a couple topics, one related to complaints and then related to licensing. But first and foremost, just to describe some of the complaints that we see related to consumers who are experiencing or feel that they've just experienced discrimination. And in the property management realm, one of the top is obviously someone who feels that they were not shown or approved for a rental property based on a protected characteristic, one of those that Steve mentioned earlier, and not even being shown the property because of a protected characteristic. And, we've seen them from, mostly race related discrimination, but also disability related discrimination. So those are fairly common among the discrimination related complaints that we receive. And then in general, just unprofessional behavior, comments being made about someone's protected characteristic, very outward comment, terrible comments, unfortunately, being made and alleged in our complaints that we receive. So just overall unethical or unprofessional behavior are some of the complaints that we receive. Next slide, please, Kara. Putting on a licensing hat a little bit, for all of you who are licensees, please know that if your license is expiring starting this year and forward, there are new continuing education requirements that you're going to have to meet related to making sure that you're well educated about fair housing and implicit bias. So please know that effective this year, you're going to have to take a fair housing course with an interactive participatory component on fair housing and take 2 hours of implicit bias courses. And then if the survey course has been extended from 8 hours to 9 hours to allow for that new implicit bias content. Next slide, please. And then for those of you who are interested in coming into the industry and getting a real estate license, please know that if you are going to apply starting next year, January 1st, 2024 or forward, that real estate practice course that you're required to take is going to have to be the new practice course that includes implicit and explicit bias training and information about fair housing laws at the federal and state level. And I think that's it for me. I'd love to turn it over to Kara at the Civil Rights Department.
Hi, everybody. As Chica said, and Steve, I'm Kara Brodfier. I work at the Civil Rights Department, the department formerly known as TFEH, and I'm an attorney in our Education and Outreach Department. Here's my boring lawyerly disclaimer. Obviously, this is for informational purposes only. We're not establishing policy rights. We're not giving legal advice. Opinions expressed by other presenters don't necessarily reflect the opinions of CRD. And I just want to give another disclaimer that the information we're presenting today, it's based on the most recent guidance as of the date of this training. But, you know, it's the responsibility of people attending to keep abreast of changing guidance and laws. And also related to that, you know, we are not going to be providing a copy of this presentation, but we are going to be recording, as Steve said, this webinar and posting a link to it. And we are also going to try and get to everyone's questions, but there are over 500 of you. Likely we will get to everyone's questions, but we encourage you to put them in the Q&A and we'll try and hit them when we can. And then depending on how many questions we get at the end, you know, we can restate some of our questions and answers there. And this is just a bit about us. We're California's Civil Rights Agency. We have a gigantic mission of protecting people of California from unlawful discrimination in employment, housing, public accommodations. We also address laws that address hate violence and human trafficking. So we have a big job, and we changed our name because we don't just do housing and employment. We enforce other laws as well. And, you know, we do many different things. We have a lot of hats. We investigate discrimination complaints, which is, I think, mainly what people know us for. Most of those complaints, if they move forward in our process, end up in mediation and are resolved. Sometimes we also prosecute violations of the law in court. We also have a council that's appointed by the governor, and they issue regulations about the Fair Employment and Housing Act and other statutes for more clarity. I recommend you take a look at those because I feel like they did a good job of writing them in a way that's pretty clear and able to be understood even if you're not a boring lawyer like me. We collect data on pay and demographics, and we do education and outreach, which is obviously what I'm doing right now. Here's just a little bit of information on accessing our information and services if you have a disability, and also more information in getting services from us if you speak a different language other than English. And now I'm going to launch into the meat of the presentation, which is fair housing protections for people with disabilities. And just to show you, I mean, we haven't put out an annual report in a little while, but disability are a huge amount of the complaints we get for discrimination in housing are around disability. As you can see, in 2020, we had over 650 complaints for disability. And if you look at the other protected categories, the next biggest one was race, but then it goes down from there. So it's an important topic. We're going to start with reasonable accommodation. So in a nutshell, a reasonable accommodation, it's just like a change to the rules or your practices as a housing provider. If it's needed to help somebody with a disability be able to use housing like anyone else. So I think many of us have an idea of what we mean by reasonable accommodation, but it can pretty much be anything as long as it can enable somebody with a disability to use and enjoy housing. And if it follows some of the requirements that I'm going to talk about now. Here's some common accommodations. I think we all know emotional support animals. I think it's probably the #1 accommodation that is requested. But like I said, it can be anything. This is just an example, or these are just examples. So, you know, more time to move out, allowing people to have a live-in aid. You know, economic accommodations can be big, allowing people with disabilities to have co-signers, payment plans, a waiver of the fee for breaking a lease if there's a disability related reason for someone needed to move out. You know, adjusting the date that rent is due. So, you know, people with disabilities get their disability payments not on the 1st, but usually around the 5th. So, you know, adjusting that date, so the person's not just racking up late fees over and over. But again, it could be anything, as long as someone can show that it's necessary. So this is like my super nerdy slide. Basically, the steps of a reasonable accommodation correspond to letters and dance. I use this ridiculous clip art just to hopefully kind of get it in your brain, so you kind of try and remember these steps. But these are the 5 steps to the accommodation process. It's disability. The person must have a disability. Request an accommodation. It's necessary. And then we'll talk about costs and effect. So what is a disability? So I'm going to focus on California law because the California laws are a little more protective than federal. But a disability is very broad. The definition is very broad in California. It can just be a physical or mental impairment that limits a person's major life activities. It could be someone's record of having an impairment. So maybe they receive disability benefits, or even if someone's just perceived as having a disability. So maybe, you know, you think somebody might have a mental health disability and maybe they don't. Even that perception is protected under California law. And what do we mean by major life activities? Basically anything you kind of need to do to kind of care for yourself on a day-to-day basis, or, you know, to sustain yourself. Can be anything like walking, speaking, reaching, lifting, leaving the house, concentrating, interacting with other people. It's also like your bodily functions, like, you know, your health, you know, respiratory system, your immune system. So it's a very, very broad definition, because anything that just limits one of these activities would be considered to be a disability. And accommodation. So as we just talked about, an accommodation is just a change to a rule or practice. You know, a person must request an accommodation, but they don't actually have to say reasonable accommodation. They can just say, hey, you know, I need a parking space closer to my unit because I have trouble walking across the parking lot due to my disability, or just, you know, because of an impairment that I have. And I think many of you know this, and I think, I would say a majority of property management companies have some sort of policy or process, and, you know, have some sort of form or something that they ask people for that. That's fine, but it can't be required. So if if somebody comes into your office and says, hey, I need a new parking space because I'm having a hard time walking, you know, that's enough. You can't, I think many times that person's going to be like, okay, cool, can you fill out this form? But it can't be required. But I usually, you know, tell people, you know, it's better to put it in writing if you can, to have a paper trail, and it's good for everybody to be on the same page. But just so you know, and people can make those requests over text or email, which just seems to be more of how people are communicating these days anyway. So I'm going to do a poll, and just to make this all a little more interesting. So I'm going to launch this now. But basically, when can somebody request a reasonable accommodation? So before moving into the unit, while living in the unit, when an eviction case is pending, after a court has ordered an eviction, all of the above, or just until an eviction case is pending. So you know, A, B, and C would just be, you know, before a court has ordered an eviction. And we're getting some great participation. I super appreciate it. I'm just gonna wait to give people a little more time, and I so appreciate, because I think this is so interesting. All right, I'm gonna end the poll even though we're having even more people. I'm gonna share the results. So we got a few of you saying before moving into the unit, while living in the unit. We had 60% say all of the above. So any time between moving into a unit or after the court has ordered an eviction, or while an eviction case is pending in court, was 35%. So let's look at the answer. I'm gonna X out of this. So the answer is all of the above. So basically someone can order or ask for an accommodation before moving in, while living in a unit, even after a court has ordered eviction. If someone's in the property, they can request an accommodation. And, you know, I've actually even seen cases where someone has moved out and they've asked for an accommodation with, like, you know, being able to get their belongings, for example. Like, you know, if someone's in a wheelchair and they were evicted and they had trouble getting all their belongings, you know, asking for an accommodation to give them a little bit more time, or, you know, allowing a different process for letting people get their possessions. But the main takeaway here is pretty much any time. Here's a slide just talking a bit about that. And our third part of the accommodations process, necessary. So the requester has to have a disability, and it has to be a disability related, there has to be a disability related reason why the accommodation is necessary. And we're going to do some examples of that. You're only required to give as much information that's necessary to demonstrate that need. The person doesn't have to disclose their disability. They, you know, don't have to show medical records. You know, usually what I tell people is, you know, just talk about your symptoms if you don't want to disclose what your condition is. You know, I have a condition that makes it difficult for me to get out of bed at certain times and motivate me to leave the house. So I want an emotional support animal so it will motivate me to leave the house and provide emotional support. Like, that could be enough. Just talking about the symptoms and how the accommodation is going to address them, just, you know, keeping things general, instead of having to say something like, I have major depressive disorder. You know, obviously the requester can say whatever they feel comfortable saying and disclosing, but it's only necessary under the law to disclose the information that's necessary to evaluate the request. So let's do another poll. I'm gonna go, all right. Alrighty. So documentation of the need for an accommodation must be from a licensed medical professional, yes or no? And I'm going to give you guys a second. And again, I so appreciate it. I love watching the numbers change and just seeing, you know, what people have to say. All right, I'm going to go ahead and end this poll. So 25% of you said yes, it has to be from a medical professional, and 75% of you said no. All right, so let's look at the answer. The answer is no. Documentation does not have to be from a licensed medical professional or healthcare practitioner. It can be from any reliable third party who has the information necessary to know about someone's disability and their need for an accommodation. You know, here's some examples of people who could be a reliable third party. Social workers and therapists. Also somebody in a caretaking relationship. So if you're a parent and you need an accommodation for a disabled child, obviously as the caretaking parent, you'd probably be in the best position to be able to document somebody's need for an accommodation. But it can, you know, it can be any reliable third party. We actually, I talked about the Civil Rights Council before and our regulations, but our regulations actually do a really good job of kind of defining this requirement. And they also talk about ways that you can evaluate whether someone's a reliable third party. And I think they're very, very clear. So I would highly recommend you take a look at those. I wish I had the citation in front of me, and I do not, but and another thing to note is that, you know, if a disability is readily apparent, so it's like obvious, then you don't have to provide any documentation. A very easy example of this is if someone uses a wheelchair or other assistive device, it's obvious that the disability is there because you can see that they, you know, are utilizing that assistive device. So there would be no need to ask for, you know, medical or any type of documentation. So let's go through a hypo. So in this hypo, Hannah applies for a vacancy with landlord Carol and notifies Carol that she will be bringing an emotional support animal. Carol wants proof that Hannah's dog is a real emotional support animal. Carol tells tenant Hannah that she needs a certificate or registration for Hannah's ESA before she can have it in the apartment. Can landlord Carol do this? And the answer is no. There's no legal requirement that an animal must be registered or certified. A lot of the, you know, online businesses, they claim to register or certify emotional support animals, but there is no registration for emotional support animals. You know, and I often tell people like that it's a waste of money, you know, to get like a card or a vest because it's not necessary. You know, at the same time, you know, if people go on, some of those websites do offer, you know, an evaluation with somebody that can write a letter, you know, and as long as they've talked to the person and are able to discuss why an animal would be needed, you know, that documentation would be fine, but there's no need to register for an emotional support animal. There was a law that was enacted a few years ago, AB 468. It confused a lot of people. But what you need to know about it is that it talks about, you know, service animals and emotional support animals, but it does not apply under these circumstances. It doesn't affect fair housing law at all. So all the protections we're talking about today stand, and AB 468 doesn't impact them. So let's move to costs, step 4. So housing providers, and I'm going to talk a bit more about animals going forward, because I feel like it's one of the #1 places where we get the most questions. So housing providers must absorb the cost of granting an accommodation unless it's an undue financial burden. What we mean is it's just so cost prohibitive that it just would be impossible, you know, and it's going to be different for everybody. If, you know, you're a large company that owns thousands of units, your resources are going to be really different than me. I'm actually a landlord, where I just rent part of, you know, my home to a few people. My resources would be really different than, you know, somebody who has thousands of units or even hundreds or multiples. So it's really going to be evaluated whether it's cost prohibitive or undue financial burden. You know, you're going to look at it on a case-by-case basis. Again, you could look to our regulations for a little more guidance on that. And, you know, if the housing provider thinks that it is going to be an undue financial burden, I've definitely represented tenants in the past that have asked for accommodations that I think would be very cost prohibitive. The housing provider can't just say, hey, I'm not granting this, this is over. They still have to engage in what we call an interactive process. It's basically a discussion just to see if there's a less costly option that could meet everybody's needs. They should not just automatically deny the request. And the E in dance, effect. So an accommodation can't be an undue financial burden, and it can't have the effect of being what we call a fundamental alteration, basically changing the nature of the landlord-tenant relationship. So a good example of this, I had a tenant, I represented a tenant who had a really difficult time shopping, and she wanted to ask her landlord to help her shop. I informed her that that is just not a thing that housing providers usually, provide us services. If you're in some type of assisted living, that might be different, but generally, that's not something that landlords and housing providers provide. So if you made an accommodation request for, a landlord or a housing provider to shop for you, that would likely be a fundamental alteration. And, the housing provider would be, legally permitted to say, no, I'm not doing that. So. All right, so let's do another hypo. This is Abigail, and I try and pull hypos as much as I can from cases that I've worked on to try and just make it a little more real life. But basically, I talked a bit about this already, but Abigail is a person with a disability. She receives SSI, and she gets her benefits on the 4th of the month. So she's asking for an accommodation to be able to pay on the 4th of the month. How would you evaluate this request? And I already kind of talked about this, but basically just showing you how we would go through the analysis and that process. Abigail receives SSI benefits because she's disabled. She requested to pay the rent after benefits come in. The accommodation is necessary because if Abigail keeps paying her rent late and getting late fees, they're really going to stack up and it could affect her tenancy. The housing provider, I think, would have a hard time saying that this was an undue financial burden. Accepting and processing rent a few days late is a very minimal cost, and it's not a fundamental alteration because housing providers accept money. It's kind of what that transaction's all about. So, all right, so let's get into something a little more detailed. This is also based on a case that I worked on. Rowan is a veteran with a mental health disability. It makes it hard for him to get out of bed, leave the house, and do other tasks. His therapist recommends he get a dog to motivate him to get out of the house. I got a dog during the pandemic, and it definitely gets me out of the house. Despite his building's no pet policy, Rowan adopts a pit bull mix who he takes on walks twice a day. So he didn't ask before getting the dog. His landlord sees the dog and serves him with a notice to get rid of the dog or he will be evicted. The notice also says that pit bulls are never allowed on the property because they are dangerous. Rowan is terrified of losing his housing, but he's also very dependent on his dog. So he ignores the notice, which I would tell people never to do. His landlord files an unlawful detainer to evict him. And at the eviction trial, Rowan explains that he needs the dog to help him manage his disability. So let's analyze some of the issues in this hypothetical. So timing, is it too late for Rowan to request an RA? We've already had a poll on this, and it seems like many of you already know the answer, but Rowan can request an accommodation at any time during the tenancy, even after an eviction has been ordered, and he's actually asking for it before that happens. So yes, he can make an accommodation request at trial. Many tenants do this. A lot of tenants are unrepresented in court, and when the judge asks them why they did something in particular, they might actually say to the judge, oh, my doctor said I needed this dog, and that's enough. Rowan has a mental health disability. He requested to be able to keep the dog despite the policy, so that's the accommodation request. And without the accommodation, in this case, Rowan would be evicted. Changing the policy to allow the dog would be a minimal cost to the housing provider, and it's not a fundamental alteration. The housing provider has a rule that you can't have pets, but the whole idea of a reasonable accommodation is a change to rules or policies or procedures. And let's talk a bit about the landlord's policy of not allowing pit bulls because they're dangerous. So a lot of housing providers have policies where they don't allow certain sizes of pets, especially dogs, certain breeds. And let's talk about if it comes into play when you are renting a property and somebody asks for, an accommodation to have an animal that you normally prohibit. So housing providers can deny a request for accommodation if it's a direct threat. So it has to, and the bar is really high, but basically if it would constitute a direct threat to the health and safety of others, if it would cause like physical damage to the property, and the risk can't be mitigated or eliminated by another accommodation. Something like this must be evaluated on a case-by-case basis and based on objective evidence. So in this hypothetical, Rowan just has a pit bull mix. There's no facts to suggest that the dog is at all aggressive or, you know, hasn't gone after anybody. It's, you know, not doing anything that would constitute a direct threat. So, you know, based on the facts presented in the Rowan hypothetical, I would say that the dog is not a direct threat. So the million-dollar question that I think probably someone has already put in the Q&A is, what if my insurance policy says, hey, no pit bulls? So that insurance policy is actually violating fair housing law. There has to be an exception for reasonable accommodations and service animals. The law just says it has to be a direct threat, and, you know, breed restrictions and, you know, blanket bans on certain breeds is not permitted because it has to be based on the temperament of the particular dog. I have been bit by one dog in my life, and it was a teeny tiny Chihuahua. And so, you know, most places aren't, you know, banning Chihuahuas. So it really depends on a case-by-case basis. So in order to deny this accommodation, you would have to show that this particular animal is a direct threat. And, you know, if the insurance company is saying, hey, you know, I'm not going to insure you, they are violating fair housing law. It is something that housing providers would have to push back on their insurance provider. You know, I know that it could result in, you know, some difficulty, but insurance companies, you know, are violating fair housing law and having these requirements. And, you know, there needs to be pushback. I have seen things changing a little bit because people are starting to push back. But I also want to reiterate that the law in this area of direct threat, not just involving animals, but involving people that might be a direct threat, the bar is very high. It really needs to be like a direct threat, you know, that's like really going to happen like immediately. So, and we're going to do one more hypo and hopefully have time to answer some of these questions. This is another case that I actually worked on. Joe was living in the same one-bedroom apartment for 10 years. His landlord has given him several violation notices due to excessive items in his unit. I'm sure many of you have experienced this. He has so much stuff it's impossible to walk. The landlord says, and Joe can open the door just wide enough so he can slide in and out. The landlord says this is a fire hazard, and she also suspects Joe may have infested his unit with bed bugs because he's bringing things off the street. The landlord is willing to treat the unit for bed bugs, but the exterminator can't even get inside to spray due to Joe's possessions. Fed up with giving Joe numerous chances, the landlord issues a 3-day notice to quit, to move out. Joe tells his landlord that he started accumulating the possessions as a way to deal with his depression, which started after the death of his partner, Stephen. Stephen's family didn't approve the relationship, and he held on to as many possessions as he could to remember Stephen. And he says he wants to clean his place, but he gets too overwhelmed. This is a big pickle. I'm not saying this is an easy thing to deal with. I think this is a scenario that many of you have dealt with. So can an accommodation help Joe? It is possible. One thing I want to note is, you know, Joe has already said he has depression, but also hoarding disorder is considered a disability. It's something called a DSM-5. It's kind of a list of different mental health conditions. You know, a possible accommodation, Joe could request that the landlord withdraw the 3-day notice and allow him to remain a tenant on a probationary benefit basis. This could include more time to clean and regular landlord inspections. This doesn't mean Joe can leave his apartment full of bed bugs and with, you know, things that are a safety hazard, but maybe coming up with kind of more reasonable ways to deal with the situation. I've negotiated things where, you know, the landlord agreed that as long as the person is addressing any major fire hazards and there's proper ingress and egress in the property, you know, in the case of an emergency, then that would be enough. You know, It doesn't have to look perfect or a way that many of us would want to live, but, just really addressing the immediate health and safety. Without the accommodation, Joe would have nowhere to live. And Joe's landlord is going to have to consider the request on a case-by-case basis. I think this is a much more difficult example than the others that I've presented. It's likely impacting the other tenants, which is also a consideration, and if it remains to be a fire hazard, the housing provider does have a duty to the other tenants to keep them safe. So again, it's a hard situation, but I didn't want to just give real life examples that were easy. So with that, here's some resources from us. And we are having another training next week from 12 to 1 on the 27th. We're going to go into some of the other issues, reasonable modifications, source of income discrimination, and protections for people with criminal histories. And here's some info from our contact information. And let's go into some questions. I'm going to ask Steve and Chica to unmute themselves too. And I don't know if you've seen any that you think would be good questions to address. We have 56, so we're not going to get to all of them.
So Kara, there are a bunch of questions about what people can and cannot ask to ascertain whether the emotional support is needed, what type of characteristics are worthy of emotional support. So can you give a little guidance on what they can and cannot ask in order to assure that the emotional support is truly a warranted request?
Mm-hmm. So one, I mean, the person doesn't have to disclose what their disability is, but they should disclose enough information to show, why there's a disability or related need for an accommodation. So, discussing kind of some of the symptoms of the disability and how the emotional support animal would help address that. And if you're getting documentation from either a medical provider or another reliable third party, that letter could include, some symptoms and, a discussion of why the animal would assist. So like with the Rowan example, the request could say something like, Rowan has a disability that makes it difficult for him to leave the house. I, as his therapist, recommended that he get a dog to assist him with this. This is needed as an accommodation of his disability. So just like very general information, a housing provider should never ask for the diagnosis. They shouldn't ask for medical records. Documentation from one of these sources should be enough. I know that, there's a tension here between people who need emotional support animals and others who are, just getting letters to have, an animal that may just be a pet. But, housing providers are prohibited from pushing further than, asking for, symptoms or, show a link, like a disability related link between the accommodation requested and the emotional support animal. So I hope that answers.
Kara, what about physical constraints about if the emotional support animal is too big? For instance, they want a horse or an elephant. Are there any type of restrictions on the size of the emotional support animal?
There can be. So I think, I think you're going to look at it on a case-by-case basis and the specific, parameters of like, someone's living space and, the reasonableness of whether or not they could have a particular type of animal. It's unlikely that like an elephant or a horse would be reasonable. I mean, you could, a housing provider could still put reasonable restrictions on things that, they're going to enforce uniformly, if, and I think it would really depend on the space that someone's renting. If someone's renting a house in the country with, space for a horse, that would be different than if you're renting an apartment in a city. But it still has to be a reasonable request. And the housing provider could come back in that situation and say, hey, an emotional support elephant is not going to work. But what about a hamster or a dog? Or, I mean, there still should be that discussion and interactive process. But it doesn't mean that you have to accept every single thing coming your way if it's not reasonable or possible.
Can the landlord charge a security deposit for a emotional support animal?
No. No deposits can be charged because it's not considered to be a pet. But if that animal, if that emotional support elephant, you know, does substantial damage to the property, then that tenant would still be responsible to pay for it when they move out.
Can a landlord require the tenant to obtain additional insurance paid for and obtained by the tenant to protect against, for instance, an emotional support animal that may bite somebody?
No. Again, it's not considered to be a pet. But if, in the situation where an emotional support animal, like say the housing provider, has factual basis to believe that the dog is aggressive, maybe it has lunged at somebody, maybe it has bitten somebody, they may be able to say that they think the dog's a direct threat to the health and safety of others, and they may be able to say, hey, you can have an emotional support animal, but not this one because it's not safe. So, but that bar is pretty high, but at the same time, you don't have to, have other tenants living in fear of a dog. It just needs to be that fear is reasonable, and they're not just like, I hate pit bulls, but they can be like, that dog is, going after me, or I'm scared, and then that might be an argument.
What happens if you have one tenant with an emotional support animal and another tenant who has allergies to that emotional support animal?
This is definitely a common scenario that comes up. So I would say you have a duty to work with both of them and try and come up with a solution for everyone. It's possible that, and again, reasonable accommodations, one of the reasons I like them is because they're not like set in stone. Like there's just, you can be creative. So in a situation like that, maybe you could move one of the tenants, or ask the person with the animal get an air filter, or specific procedures for like when they're bringing their animal out in the hallway. Like I think there's many solutions, and I feel like often when you get people together to work on a solution, it's often the best way to deal with a situation.
And if you can back up the slide presentation to the slide that displayed the resources, we have several people asking for
Yes,
that resources slide again.
Let me find, this is my, hold on. Oh, there we go. So basically, we have on our website, we have on our website many different resources. That's the URL that you would go to, but even if you just go to our website and get the resources tab, you can find it. The resources are laid out by subject matter, so like housing or employment, and then you can find these resources. And also we did record this webinar. And so we're going to send a link out to everybody who attended in the next few days with a link to the recording, so you can refer back as well. But I highly recommend you take a look at our resources, and we always are posting new things. So,
and can you remind people again when part 2 of today's seminar will take place?
Sure. So it's on Thursday the 27th from 12 to 1. We're gonna expand on some of the info that we started with today. We're gonna talk about source of income discrimination. We're gonna talk about reasonable modifications, which is kind of like the other side of reasonable accommodations, and protections for people with criminal histories. We might hit a few other topics as well. But I highly recommend you attend part 2. And I hope you found this to be helpful. I think we have like 4 minutes there's 87 questions, so I wish I could hit them all. But
so here's another question. Are there exceptions under the non-discrimination laws for rental units or for single family residences?
Oh, exceptions? There aren't many actually under California law. The main one is if you're a housing provider that's sharing the space with the other tenants, and you're only renting like one room. But there aren't many other exceptions for fair housing laws. There are for other laws that protect tenants, but not for the fair housing laws.
And is there a limit on the number of emotional support animals that one person or tenant can have? Can they have both the emotional support elephant and the emotional support horse?
They can. You know, there isn't a limit, but you do need to show a disability related need for the multiple animals. You know, and again, we're talking about reasonableness and feasibility. You know, having 15 dogs in a studio apartment, probably not very feasible or reasonable, but there may be a way to make it work. I don't know. But I do think, you know, housing providers are able to set reasonable limits, you know, to protect their property and other people and health and safety and things like that.
Kara, if your insurance provider is canceling their, you know, coverage because of ESAs that are being allowed, is that something that the property managers and landlords can file a complaint about?
Yes, they could file a complaint. And I would say go do that. I think that, you know, I think insurance providers are starting to understand that they're not allowed to do that. It's under both federal and state law. But there are many that still just have it in the rules or it's like hidden in the contract, you know, but they are violating fair housing law. So yeah, go ahead and I would say take them to court yourself too if you want, because I think you'd have a pretty reasonable claim if you can show, hey, this person made a reasonable request for a dog that's a pit bull, there's no direct threat, and you're still denying my insurance.
And we've received a couple questions asking about whether a real estate license is needed to do property management work. And the quick answer is typically if you are doing work for another person and in expectation of compensation, and that work being basically the buying or selling of property or the renting of property, and you're doing it in expectation of compensation for another, you do need to be licensed by the Department of Real Estate. The clear exception to that is if the property itself, you are the owner of that property, in which case it's a principal activity. And therefore, as the owner of that property, you don't need to have a license to engage in the rental or the sale of that property.
And Steve, if I may add to that, another popular exemption is the resident manager. So if there's a large apartment complex, that complex needs to be managed by a licensed person if they're not the owner, but the resident manager that lives in the property and helps to, you know, collect the rents and perform upkeep, they do not need to specifically have a real estate license as the resident manager.
And that takes us to 12:59. So we have 1 minute for farewells. Kara, Chica, anything you want to add or say as we say goodbye to our guests today?
I just want to say thank you. You guys were great with participating. We have almost 100 questions. You know, you answered the polls a lot, and you know, I'm excited to see you next week and encourage you to check out our website or, you know, go on DRE's website as well to, you know, for more information and resources.
Chica, anything you want to add on behalf of the Department of Real Estate?
Just thank you very much for attending. This is a wonderful audience. As Kara mentioned, very interactive and eager, and that's all we can ask for.
And I just want to add special thanks to Kara and her colleagues at the Department of the Civil Rights Department because they're wonderful to work with and we enjoy our partnership. So thank you very much for a very thoughtful and well-presented presentation today.
And thank you guys as well. And we'll see you all next week. Bye.
And that concludes today's presentation. Thank you.